and 204A of the Pension Act, respectively. A copy of the charge sheet was attached. It indicates Massacre Sierra B 605 of 2021, and the applicants appear thereon as A5 and A6, respectively. The applicants were then remanded and applied for bail. However, before the bail application could be heard, when the matter came up for mention on 15 September 2021, the resident Chief State Attorney Massacre presented an amended charge sheet with 2 more counts of terrorism and abetting terrorism. A copy of the charge sheet was also attached, and it indicates Massacre Sierra B 605 of 2021, and the applicants still appear as A5 and A6 respectively. On 20th September 2021, the applicants were granted bail, and their release from Chibo prison was directed pending trial. A copy of the ruling was attached and marked C. The applicants were allowed to move out of the prison, but immediately after, a Toyota Hiace, commonly known as drone, intercepted them, and over 5 military personnel covering their faces jumped out, put them on gunpoint, pushed them in a vehicle, and drove them to an unknown place where they were detained. They were later taken to Kireka Special Investigations Unit of the Uganda Police Force on 27 September 2021 to record statements. On 29 September 2021, the applicants were arraigned in Massacre Chief Magistrate's Court on charges of murder contrary to sections 188 and 189 of the Pension Act and remanded to Chibo prison. A copy of the charge sheet was also attached and marked D. This charge sheet indicates LWG Sierra B 203 of 2021, and the applicants appear thereon as A1 and A2 respectively. The applicants have since been committed to High Court in both cases. The first one being committed to the High Court International Crimes Division by criminal case number 004 of 2022, Uganda versus Ssewanyana and 6 others, and the second one in the High Court of Uganda at Massacre Sierra by CRA 258 of 2021. That's Uganda versus Honorable Ssewanyana Rosius, Honorable ssegirinya Muhammad, and Senyonga Wilson alias Nyonga Tony. A copy of the indictment and the summary of the case was attached and marked F. The applicants seek for orders to consolidate the 2 criminal case files, one currently at the High Court in the National Crimes Division, Kampala, and another currently at Massacre High Court for reasons that the 2 criminal case files have a common theme, set of circumstances, and common questions of law and fact which can be conclusively determined by this court. Below is the respondent's case. The respondent's case is contained in the affidavit in reply of Mr. Thomas Gatiko, Assistant Director of Public Prosecution. He raised a preliminary point of law in paragraph 5 of his affidavit to the effect that consolidation of criminal cases is alien and does not exist in the criminal law and procedure of Uganda. He confirmed that the applicants are charged in both criminal cases and they have been committed in both of them as described, but vehemently objected to the consolidation of the 2 case files. He averred that the 2 criminal cases are totally different, with different questions of law and fact, and cannot be determined by this honorable court. He further stated that the 2 criminal cases are factually different and cannot be joined in the same charge sheet or indictment. His further reason for opposition is that the offenses in the 2 case files were committed in different places at different times in different ways with different parties, both accused and victims, and for different motives. Mr. Gatiko further averred that the 2 criminal cases are before different courts with different trial procedures, and joining the charges and parties would cause a miscarriage of justice. For purposes of clarity and convenience, the 2 case files that are the subject of this application shall be referred to by their police reference numbers, namely Massacre Sierra B 605 of 2022 and Rengo Sierra B 203 of 2020. Massacre Sierra B 605 of 2021 and Rengo Sierra B 206 of 2021. What are the issues before me for determination? From the pleadings, the following issues have been raised for determination. One, whether or not criminal cases can be consolidated under the existing criminal law and procedure in Uganda. Two, whether or not Masaka CRB 605 of 2021 and Rengo CRB 203 of 2021 can be consolidated. How have I resolved issue one? Whether or not criminal cases can be consolidated under the existing criminal law and procedure. This issue arose from the preliminary point of law raised in paragraph 5 of the accident of Mr. Thomas Jatiko to the effect that consolidation of criminal cases is alien and does not exist in the criminal law and procedure of Uganda. At the beginning of the hearing of the application, counsel for the respondent sought to argue the preliminary point of law containing that it would dispose of the whole matter. However, this court guided that the matter should be handled substantively and the preliminary point of law would instead be framed as an issue. Chief State Attorney Tom Hendo Joseph contended that consolidation of criminal cases is alien to criminal law and procedure and is a preserve of civil procedure because it is expressly provided for under Order 11 Rule 1 of the Civil Procedure Rules. He further argued that the procedure the applicants should have adopted was to apply for joinder of counts and persons as provided for in section 86 and 87 of the Magistrates Court Act and sections 23 and 24 of the Trial Documents Act. He further submitted that those are the provisions of the law that regulate procedure of the court in criminal matters where common questions of law, facts, and transactions arise. He stated that with consolidation, the two or more files have to be put together and handled as one. While with joinder of persons and counts, all persons and counts have to appear in one charge sheet or indictment, and they should have the same summary of the case. He further argued that the applicants ignored the right provisions of the law and relied on section 17(2) and section 33 of the Judicature Act to bring this application. While citing the case of Honorable Alan Ssewanyana and Honorable Ssegirinya Muhammad versus Uganda Criminal Appeal number 294/2021 and Makundi Moses versus Uganda Criminal Appeal number 068 of 2020, he submitted that an application based on any wrong law should be struck out. In the above two cited authorities, the appellants filed appeals in the Court of Appeal against the orders of the High Court, denying bail and cancelling bail respectively. The Court of Appeal held that the right to appeal is a creation of statute, and appeals from the High Court to the Court of Appeal do not arise from interrogatory orders, but from the orders of conviction and sentence as per section 132(2) of the TIA. In both cases, the Court of Appeal struck out the appeals on a preliminary point of law. Mr. Tom Hendo finally submitted that the application is bad in law for being brought under wrong provisions of the law and should be struck out and the matter be disposed of. In response to this, Honorable Elias Mulandi Council and the Lord Mayor of Kampala City submitted that what the respondent called the preliminary point of law was actually a response to the applicant's submissions. He further argued that the application was brought under section 17(2) and section 33 of the Judicature Act, which give this court inherent powers to prevent abuse of court process. He further contended that consolidation and joinder mean one and the same thing and is just a matter of semantics. He further contended that consolidation of criminal matters was handled in the case of Aliobe Joseph, Bada Alfred Alaya Sina versus Uganda. It is miscellaneous criminal application numbers 005, 006, and 00717 of 2016. Where Honorable Justice Stephen Mwilu consolidated three miscellaneous applications for bail and handled them as one. The principal legislation that governs criminal procedure in the High Court in Uganda is the Trial Indictments Act. Just as the principal legislation that governs civil procedure is the Civil Procedure Rules, consolidation of suits is specifically provided for under Order 11 Rule 1 of the Civil Procedure Rules and provides as follows. Quote, where two or more suits are pending the same court in which the same or similar questions of law or fact are involved, the court may, either upon the application of one of the parties or of its own motion at its discretion, and upon such terms as may seem fit, A, order a consolidation of those suits, and B, direct that further proceedings in any of the suits be stayed until further order. However, I find no provision in the TIA that allows consolidation of criminal cases. On the contrary, the TIA provides for joinder of counts and persons and not consolidation of criminal cases. In an effort to support the application for the consolidation of criminal cases, counsel for the applicants relied on the constitutional petition number 30 of 2014, Kazinda Geoffrey versus Attorney General, Uganda versus Ojia Santo, and 4 others, and then Ariobe Joseph. Upon perusal of the first 2 court authorities, I find that the principle that was discussed was joinder of counts or offenses and not consolidation of criminal cases. In the Ariobe case supra, the applicants were jointly indicted for the offense of murder, contrary to sections 188 and 189 of the Penal Code Act. Each of them filed a separate application for the grant of bail, and they were all before the same court and the same judge. The learned judge observed that the Trial and Indictment Act is silent about consolidation of criminal cases and criminal application, but consolidation is consistent with case management principles. He therefore found it proper and convenient to consolidate the applications and handle them as one. I find that this case is distinguishable from the facts before this court. In the Ariobe case, the 3 applications arose from one criminal case, and the applicants appeared on the same charge sheet, while the application before this court seeks to consolidate 2 separate and distinct criminal cases. Besides, all the 3 applications were before the same court and could be easily and safely consolidated. This is different from the facts of this application, where one case file is before one judge in Masaka and another is before another judge in Kampala at the International Crimes Division. The question I ask myself is, can I consolidate what is not before me? In my view, cases before the same court does not mean same court level. As a judge at the International Crimes Division, can I, by the ruling of the court, order a judge, another judge of the High Court, to produce a case file before me consolidation? I will answer this question in a negative. At this point, I wish to observe that the applicant's case was mainly hinged on the infringement of the right to a fair hearing as enshrined in Article 28 of the Constitution, as discussed in the Kazinda case. In the Kazinda case, 3 justices of the Court of Appeal held that offenses with which Mr. Kazinda was charged fell within the definition of the offenses of the same character and could adequately have been joined in one trial. The numerous trials for offenses similar in character amount to a deprivation of the right to a fair hearing and contravenes Articles 28(1) and 9 of the 28(1) and 9 of the Constitution. That failure to adhere to the above provisions of the Constitution would lead to decreased view of charges against an accused person, which infringes on the right to a fair hearing. However, this court is unable to rely on any arguments referring to that case because on the 12th day of February 2021, the Supreme Court in Constitutional Application number 27 of 2020, the Attorney General versus Kazinda Geoffrey issued an order staying the execution of the judgment and orders in Constitutional Petition number 30 of 2014, pending the hearing and the determination of the intended appeal by the applicant. Honorable Elias Lukwago invited this court to find that joinder and consolidation are just semantics, but they have one and the same meaning. I respectfully disagree because in practice, they actually mean different things and cannot be performed in the same way. Whereas in consolidation, two or more distinctive case files are brought together and handled as one. Joinder means having two or more persons or offenses on one and the same charge sheet or indictment on this, and on the same summary of the case. It should also be noted that under Order 11, Rule 1 of the CPR, consolidation is permitted when two or more suits are before the same court. In light of the above, therefore, I agree with counsel for the respondent that consolidation of criminal cases is alien to criminal law and procedure because it is not provided for in the laws. This would ordinarily dispose of this application at this stage. However, Honorable Meda Ssewanyana and Honorable Arias Lukwago invited this court to exercise its inherent powers under Section 17(2) and 33 of the Judicature Act and order for the consolidation of the two case files in order to prevent abuse of court process. Having listened to the submissions of counsel for the applicant and the court decisions they rely on, I found with you that whereas the application seeks a consolidation of the two case files, they actually intended to mean joinder of offenses and persons on one indictment and not consolidation. This is because in their submissions, when asked how consolidation will be done, Honorable Meda Ssewanyana explained that the count of murder in Rengo Sierra B 203 of 2021 would be added on the indictment in Masaka Sierra B 605 of 2021, and the two would be handled as one. This is clearly joinder of persons and offenses and not consolidation of criminal matters. In the spirit of administering substantive justice, this court will exercise its discretion and treat this application as if it was an application for joinder of offenses and persons so as to conclude it on its own merits. This therefore takes me to the second issue, which I will rephrase as follows. Whether the persons and offenses in Rengo Sierra B 203 of 2021 can be joined on the charge sheet or indictment of Masaka Sierra B 605 of 2021 that is before this honorable court and be handled as one. Honorable Arias Lukwago submitted that Masaka Sierra B 605 of 2021 and Rengo Sierra B 203 of 2021 arise from a series of the same transactions and therefore should be handled together in order to avoid abuse of court process. It was his contention that the two cases are inextricably intertwined so much that one cannot be divorced from the other. He gave a chronology of the events and submitted that the charges in Rengo Sierra B 203 of 2021 were as a result of a series of murders that happened in Greater Masaka, and it only came after the applicants had been granted bail by the High Court in Masaka. High Court in Masaka Sierra B 605 of 2021. He wondered why Rengo Sierra B 203 of 2021 did not come first, since it indicates that the offense was committed on 2nd August 2021, which is way before the other murders which are said to have happened on 23rd August 2021. He further argued that Rengo is part of Greater Masaka, and the offense in Rengo Sierra B 203 of 2021 is part of the series of murders that were happening in Masaka at the time and are acts of terrorism. On the other hand, Chief Secretary Richard B. Bunka, while citing Sections 23 and 24 of the CIA, which regulates framing of charges in criminal matters, vehemently opposed the joinder of offenses and persons. He submitted that the offenses and the persons in the two case files cannot be joined in the same indictment. Otherwise, there would be a misjoinder and resultantly a miscarriage of justice. He contended that the parties in the two cases are completely different for the applicants, except for the applicants who appear in both. He also argued that the offenses were committed at different times, in different places with different facts and different motives. He further argued that whereas in Masaka Sierra B 605 of 2021, the motive of the murders was terrorism, in Rengo Sierra B 605 of 2021, the murder was an isolated incident and the motive is unknown. He finally submitted that allowing joinder would mean charging all the people afresh and committing them for trial and let them undergo fresh pretrial process which would cause more delay. In order to resolve issue 2, this court would be expected to answer 2 questions, namely, 1, can the offenses in the 2 case files be joined and charged in one charge sheet or indictment? And B, or 2, can the persons in the 2 case files be joined in one charge sheet or indictment? The law governing joint outcomes in the High Court is provided for under section 23 of the Trial Indictments Act, and it provides as follows. 1, any offenses, whether felonies or misdemeanors, may be charged together in the same indictment if the offenses charged are founded on the same facts or form or are a part of a series of offenses of the same or similar character. Whereas more than one offense is charged, number 2, whereas more than one offense is charged in an indictment, a description of each offense or charge shall be set out in a separate paragraph of the indictment called count. Applying the above law to the facts of this application, I find that offense in the charge sheet of Rain, CRB 203 of 2021 is murder, and I believe that it is of the same or similar character with offenses in the charge sheet of Massacre, CRB 605 of 2021, within the meaning of section 23(1) of the TIA. This would therefore mean that the offenses may be joined together in the same charge sheet. The first question, therefore, is answered in the affirmative. The other question is, can the persons in the 2 case files be joined in one charge sheet or indictment? Joinder of persons is provided for under section 24 of the TIA, which provides that 1, which provides that the following persons may be joined in one indictment and may be tried together. 1, persons accused of the same offense committed in the course of the same transaction. 2, persons accused of an offense and persons accused of abatement or of an attempt to commit that offense. 3, persons of more offenses than one of the same kind. That is to say, offenses punishable with the same amount of punishment under the same section of the Penal Code Act or any other written law committed by them jointly within a period of 12 months. And 4, persons accused of different offenses committed in the course of the same transaction. It goes on up to 6. Considering the facts in the instant case, the only provision that would be applicable is section 24, subsection 3 of the TIA. If the applicants were the only accused persons appearing on the charge sheet of Brentwood, CRB 203 of 2021, then they would safely be added to the charge sheet of Massacre CRB 605 of 2021. This is because the applicants would be, and I quote, persons accused of more offenses than one of the same kind, brackets, that is to say offenses punishable with the same amount of punishment under the same section of the Penal Code Act or of any other written law committed by them jointly within a period of 12 months. However, there is another accused person, namely Ssewanyana Wilson alias Nyonga Tony, A3, on the charge sheet of Rengo CRB 203 of 2021, which makes the joinder of person impracticable. Besides, Massacre CRB 605 of 2021 also has 5 other accused persons in addition to the applicants. Had it been that A3 also appears as one of the accused persons in Massacre CRB 605 of 2021, or there were no other accused persons on the charge sheet of Massacre CRB 605 of 2021, then the joinder of persons would be possible. However, A3 is a total stranger to the case that is currently before this court. As such, bringing A3 to the case before this court with the accused persons is not connected to in any way, and for charges is unaware of, would be a misjoinder of persons. In light of the above, therefore, it is clear that the persons in the charge sheet of Rengo, CRB 203 of 2021, cannot be safely joined on the charge sheet of massacre Sierra B605 of 2021, thereby answering the second question in the negative. Having made that finding, I also find that failure by this court to order for a joinder of counts and persons in the two case files that are the subject of this application does not in any way violate the applicant's right to a fair hearing and is not prejudicial to them in any way. The two matters can be safely handled separately. Counsel for the applicants emphasizes that charging of the applicants in two separate files is an infringement of the right to a fair hearing as enshrined in Article 28(1) and Clause 1 and 9 of the Constitution, which provide for the right to a fair and speedy trial and the right against double jeopardy. Though the Supreme Court has stayed the execution of the judgment of the Kazinda case, on which counsel for the applicants based their submissions for this argument, I believe this court has agreed to give its view on the right to a fair hearing as enshrined in Article 28, Clause 1 and 9 of the Constitution in light of the facts of the instant case. My view is that charging the applicants in two case files does not deny them their right to a fair and speedy trial because, as this court was informed, in both case files, the accused persons have already been committed to the High Court for trial. Counsel for the applicants also contended that charging the applicants in the two case files amounts to double jeopardy. Double jeopardy is provided for under Article 28 and Clause 9 of the Constitution provides as follows. A person who shows that he or she has been tried by a competent court for a criminal offense and convicted or acquitted of that offense shall not again be tried for the offense or for any other criminal offense of which he or she could have been convicted at the trial of that offense, except upon the order of the superior court in the course of appeal or review proceedings relating to conviction or acquittal. Clearly, in the facts before this court, there has been no conviction or acquittal of anyone. Therefore, this leaves us with the aspect of courts or for any other criminal offense of which he or she could have been convicted at the trial of that offense. It is my view that it cannot be said that the applicants could have been convicted of the murder in Rengo CRB 203 of 2021 in the trial of massacre 605 of 2021 for it to amount to double jeopardy. This is because the offenses and the persons in the two cases are different. I also need to observe that sections 23 and 24 of the TIA that regulates the joinder of offenses and persons use the word may and not shall, leaving it at the discretion of the Director of Public Prosecution to determine which offenses and persons to jointly charge. This discretion may only interfere with upon satisfaction that there was abuse of the legal process. Counsel for the applicants vehemently argued that charging the applicants separately was an abuse of the legal process. However, no evidence was adduced to the satisfaction of this court to that effect. In conclusion, this application hereby fails and is accordingly dismissed with no order to post.
My Lord, we oblige that before you respectfully. I'm just putting counsel record. It's not something major. It may be recorded that the Honorable Shamim Malende came in with proceeding. May she be put on record as present. Thank you, Lord.
Thank you to both parties. Is there anything else you want to say?
Yes, the last one, my Lord.
This time is with
Yes.
double Z.
Yes, that was it. Not in the previous ruling, it was single.
Apologies for that.
My Lord, we have a pending application for bail before you. whereupon, due to the decision just handed down to us this morning, leaves this court to the discretion on whether to fix that application or not.
You want me to fix it?
Yes, we would prefer that the same be fixed. Would be obliged.
You want me to fix the bail application? Mr.
Tulia Musima.
You want me to fix the bail application? Because I don't want us to waste time. If I have said I don't have the master file and I cannot pick it from my colleague, how do I handle a bail application for a matter with master file? Considering what I have already told. I just don't want us to waste time. And let's make this as important, save time. Because you see, we are saying this case should be handled expeditiously. And I am committed to do that. So, fixing it, I have no problem, I can fix it, but you know the result. In light of what I have said this moment.
Well, there are two things. I would not want to go into this decision.
No, of course we are not supposed to.
I'm not supposed, it would be unprofessional for me to go into whether you have jurisdiction. Because I would then say there's unlimited jurisdiction. I don't want to poke into this. But again, you have the powers to transfer this file if you believe it is not properly for you.
I thought you also have the responsibility to file your matters in the right court.
My Lord, ante this decision, we knew we were properly before you. And we still believe.
So what do you want me to do with the other application, the bail application?
It may be.
Okay, I can give you a date.
Transferred, yes, ma'am.
I can give you a date for it.
Then we can meanwhile
Yeah.
make a decision on this.
Yes, Melody will have this on the date.
You have not been served.
Yeah, that's what I was going to make my Yeah, so we haven't been served, my lord.
Yeah, my lord, just a simple clarity. Especially putting in mind that this honorable court has jurisdiction. Because of not resting,
Don't take me there.
most blood, my humble prayer would be, instead of fixing the matter, because we had already fixed the main court, this honorable court still has the authority and the powers, if possible, to transfer the file to the other side, so that at least that case is handled that side, and we proceed with the main cause, Your Honor. Instead of now fixing it, then coming in for hearing and all that.
Now you see, because you represent different people, you are beginning to.
Exactly. Because I'm mindful about other accused persons before this honorable court.
No, so I'm giving them a close by date. And yeah, I can actually ask both of you to come, if you have not been served, so that we resolve this.
Yeah, let's mention the matter before you to ask for directions on the same. Mention.
Can put this to charge Monday next week?
Well, for mention, we shall take it. My lord. At least one of
Actually, I'm
us.
going to give it a date right now, so you can pick it and serve it on them.
Yes.
Yeah, and I expect them to come on the third. They have not filed that.
Yeah, I'm saying let's put it for mention. Any of us can be around, so the date will suffice. Let's just mention
Okay.
that matter on that date. And my clients wanted to state anything, it's within the powers of this one of the court. Decide whether to hear them.
Okay, I fix it for mention on 3rd of October at 9:30. The days are fixed. Mr. Williams with the double Z.
Yes.
Does any of the members say something? I believe the Honorable Ssewanyana. Please.
Thank you, Your Lordship. Your Lordship, we have just received disturbing news this morning from our lawyers that you have made a decision to hear ex parte an application for witness protection from the state or from the prosecution side. Mindful of our status, mindful of the kind of jobs that we do, Your Worship. We get these jobs through a competition. We have enemies as members of parliament. We know that anything can happen, especially in regard to witness protection. We have people in our constituencies who lost jobs in favor of us who became members of parliament. We go through a competition, a competitive process, Your Lordship.
Those who supported you?
Those who supported us and those who did not support us, they are all there. So we are very mindful of why the state is asking for witness protection, because he can do anything, can get anyone, any of our competitors to come to court here. We are very mindful of that, Your Worship. So that's why we had given orders to our lawyers to be party to that application and make substantive arguments in favor of us as they are chosen. We don't feel to be having a fair trial if the ones who are going to give, who are going to be witnesses in our case, are going to be protected, are going to be lost from us, and the public are going to be
Honorable
hidden.
Ssewanyana, I can cut you short.
Yes.
I can cut you short and tell you that I don't know whether your lawyers shared with you the ruling that I made. If they did not, then they should, so that you get to know the reasoning why I say that application should be expanded, because the law allows actually provides for mandatory expert application. But to array your fears is that the court has not made any orders yet in that application. And that is what we are going to listen to from them. And court, you just be comforted that court cannot, you cannot allow it to be tried by ambush. That application that they have sought, which is expertise, is for me to determine whether they should disclose to you when and how. Have you got it? So they have not allowed them not to disclose at all. I am going to assess their arguments and then I will make a decision. So you don't have to be worried about that.
Thank you, Your Lordship.
Honorable Ssewanyana, is there anything you want to say? Okay. Okay, I wish you a good day. And I will give you a ruling, I will sign the book with the ruling in the next 30 minutes.
Yes, Honorable Wange, how are you?
Let me get it photograph. Let me get this.
You can do this from the other side.
Let's get a copy and bring it before you.
Give us some.
Give us away.
Can you move? Hello, gentlemen.
Muhabaretedde muno.
I'm going to give it to me. You'll give it to me. You get a photocopy, then give it to me. Sign it. Sign it. Okay, come in. You get for me a photocopy.
Abasajja basiba.
Abaana baffe baveeyo mu kkomera basumulule kuba tebalina musango. Tebalina musango. State buli nnaku n'alemesa. Buli kimu atulemesa. Lwaki alemesa abaana baffe? Musango baali ku kasino kuvaayo ne kubeera wamu. N'ebiseera era ayagala atubonyeebonya atutambuze tugende e Masaka. Twali twakavaayo ate kati era tugenda kuddayo. Kuba siteeti yagambanga omusango guli ogw'e Masaka tayagala bagugatte na guno. Ate ng'omusango gwe gumu lwaki takkiriza ne babigatta? Nga naye muzadde, siteeti oyo si muzadde, ye tazaalangako. Balaba okubeera mu mbeera bwe. Simanyi na kumanya.
totangako yadde akamyu naye
bagambe buli ali mu kkomera yabba
mazima go ge gakusibya.
Sina katini.
Rooted out of the Constitution, which gives unlimited jurisdiction to this honorable court to make the orders that we sought. The orders sought were that the matter in Masaka, now in Masaka, and the matter now at the ICB are more or less the same. The charge of murder in Masaka arising out of the Greater Masaka is the one still being held in Masaka. We also have charges of murder here in the ICB. So we believe that these are same offenses which can be joined under one file to avoid the constitutional obligation to court to avoid double jeopardy and the right to fair hearing. What we've had today is court has told us that it does not have that unlimited jurisdiction, that this high court here at the ICB is different from the high court in Masaka. I think this is a matter even a law student will be puzzled about. I think the law is being changed. The law we know that the way we know it from the Constitution, the High Court has unlimited jurisdiction. The High Court in Masaka and the High Court here are on the same level. It is not about the persons sitting on that bench, but we're respectful. Going to look at this as a matter of law, but we may need to really find a way of not giving it on the records of the court. That is a decision to be made collectively with our clients, because we have to balance their rights of being inside prison and going on other measures that can delay us further. So it's not a decision that I can make before I consult, but we do not want such a decision to remain on our books.
So talking about the issue of bail,
Again, it affects, this decision means that even our bail application before this honorable court may be improperly before this court. If the other file cannot be consolidated here, if this court believes it cannot hear matters relating to the file in Masaka, we think then it is two positions. The previous judge had such an application as a matter of rights arising out of the other file and even made a decision. Now we are getting a conflicting decision. It is in such cases where we find two different positions from judges or judicial officers.
Okendedde bbaga yange naye nga mugyewaleko gyonna gye mutuusaako engalo. Leero tukoledde ku YouTube kokka ke ali mukulembeze. Bbaga yange mbadde ngirese muno.
That a joinder is allowed and the consolidation is not allowed.
No,
What does it mean?
No, the judge said she can join the